itself is not a hotbed of construction defect litigation as opposed to some of the other states, but we'll make a go out of it and see what we come up with. If you download the materials that West Coast Casualty produced, you'll see under this seminar heading, we produced and created what we call a primer. It's kind of a bullet point, state by state, bold-faced, and little primer or kind of a cheat sheet or cliff notes of some of the major topics that are relevant to construction defect litigation in the Northeast, like statutes of limitations and repose, allocation, definition of an occurrence, time on risk, et cetera, et cetera, et cetera. So rather than rotely reading that back to you, because you could look at it at your convenience if you need it, if you want to refer to it, it's there, and obviously it's not all-inclusive and not incredibly comprehensive, but it's a great, great tool and a great guide, and we hope you find it as useful as we did. But what we decided to do, and because we have an hour, and now because of me, significantly less than an hour, and we have 7 people here and several states to go through, in talking about this, what we're going to do is I'm going to turn the floor over to John Graceffa, who is going to discuss both the facts and some very interesting developments in a Connecticut Supreme Court case that recently came down that John's involved in. And we're going to use that as a basis to kick off a discussion among and between all of us, and maybe all of you, with regard to comparisons and contrasts of some of the issues that arise and how they'd be handled on a procedural, substantive, coverage, insurance basis in many of the Northeast states, and also comparing and contrasting them with the more typical experiences that many of the people here have with the Western states. All right, let's take it into more of the, not more practical, but more of the procedural and substantive aspects, not necessarily of insurance coverage law or construction law, but the way cases are actually handled in the Northeast. And obviously that's a gross generalization to say the Northeast, because New Jersey cases are handled completely differently from New York. And although I don't have personal experience, I am sure either among or between the New England states, there's radical differences, notwithstanding the law, in the ways that cases are handled. Typically in the Northeast, and I'm assuming very much like the West, the vast majority of construction defect cases, whether they're complex or not, do not go to trial, especially the complex ones. In New York, we have, and this is something that always amazes people from the West, we don't really have expert discovery in CD cases. It is not mandated, it is not required. In some cases, it's not even allowed. There is very, very little expert deposition. There is voluntary disclosure, but the statute, the New York Civil Code, which does not follow the federal rules of civil procedure, shockingly, is 3101D, which is expert interrogatories, which are often answered on the eve of trial and are allowed to be answered on the eve of trial, and they're just interrogatories. You have to state who your expert is and what the nature of his or her opinion is and when they've testified before, but there's no exchange of reports, mandatory exchange of reports. Certainly drafts of report are not discoverable, and there's virtually no expert deposition. In many cases that are complex, it's in the plaintiff's best interest and in the defendant's best interest to exchange disclosure, because to get an idea of what the case is. But from a procedural point of view, other than in the commercial part, which I won't bore you with how the New York courts are set up, there is no expert disclosure that's mandated other than the 3101D or other than voluntary. And that contrasts with, I assume,
most states.